Hey, Deserving listeners, we have a very special guest with us on the podcast today, my attorney, Fran.
Hello, here I am.
You've been on the podcast before, years ago, and now you're back, and I'm glad to have you. So why don't you introduce yourself to Podcast Land and maybe where people can find you?
Hi, everybody. I'm Fran Schopick, JD MSW. My training is both as an MSW and as a JD. The work that I do now as a lawyer is I represent people to the Department of Health when they have complaints against them, usually mental health workers, sometimes other healthcare providers, but all to the Department of Health. And then I also do risk management consultations on ethics and other practice issues.
Yeah. So disclaimers, for example, website disclosures.
So website disclosures, I have my work as a lawyer here in Washington. My website is francisschopick.com. I also have two other projects. One is called the Working Alliance.
And what do you do there?
What I do there with a colleague, we do templates for disclosure forms, disclosure statements, which are also often referred to as informed consent. That comes from my work helping people with disclosure statements because I personally feel that the disclosure statement is the single most important risk management tool that you have at your disposal. It is super important. If it's well written, and by well written, I mean it reflects how you work and the choices that you make as a clinician. If you put that stuff in the disclosure form, so that people are on notice from the very start. And if there's anything that people don't like, they can tell you, or they don't have to work with you. And, you can say, well, this is how I work. I'll give you a referral. But to get that stuff addressed at the very beginning is just worth so much. And it saves people so much trouble, so much heartache, so much money if they have a complaint. It's amazing. But it's not only having the language on the piece of paper or on the screen, it's the therapist understanding what is in it and understanding how to sell it. And I think of it actually as, I used to be a musician, you know that, right? And it's kind of like if you look at notes on a paper, you see that it's music and you might be able to read it and see what it is. But it's when somebody executes it, when they sing it or play it, an orchestra, that when you actually hear it, it's much more meaningful. And so so I would not only help people write their disclosures, but also understand them. The problem with that is, and I still do that for people who like to work with me individually, but it takes a lot of time because it's kind of like one-on-one teaching, really. It takes a lot of time, and I don't want to impose that added time if they don't need it. So if they want to, they can go to this other site, the Working Alliance, and they can get something to start with, and that's throughout the whole country because it's basically information and education. So it's not me acting as a lawyer, it's offering educational resources. So anybody throughout the country can contact me for that at the Working Alliance, info@theworkingalliance.com. And then the other project I have is with another attorney. It's called Litigation Survival School. And in that project, we want to help educate people about how to navigate the court system. And that's focused on people who are either pro se, meaning without a lawyer, or who have a lawyer and want to be able to help the lawyer or want to be able to understand what's going on. There's so many things that people don't understand about it, and we want to help them at least understand what's going on and how they can be helpful.
Yeah. Yeah, I appreciate you and others like you who are both clinicians in mental health and attorneys because it is hard to get attorneys that understand our world, and it's hard to get ethics and legal experts who are clinicians who actually know the law. So I appreciate you a lot and will call you a lot. And I called you a lot when the following thing happened, which is that I received a complaint. So I thought we would go over that briefly before we talk about a case that you actually worked on recently. We were talking on the phone and we were just chatting and you brought this up. And I said, let's talk about that on the podcast. Anyway, but to review the complaint against me, I don't know this, it's just speculative, but in the middle of 2022, I started to react to the Johnny Depp Amber Heard trial. And I had been gaining fame up until that point, not like massive fame like Mr. Beast on YouTube or something, but, in my little way, gaining notoriety online and on YouTube. And when I started reacting to the Johnny Depp Amber Heard trial, it catapulted me up to another plateau of fame and notoriety. And therefore, people started to notice what I was saying. And although 99% of people were neutral or positive about what I was saying, when you have 1% of like 10 million people, that's thousands of people that are negative about you. And then if you take 1% of the 1% who actually will take action to try to harm you, that's, what is that? One in 10,000 of the people who come into contact with you want to actually harm you. It's a pretty low percentage, but when you have 10, 50 million people that are coming across your videos on YouTube, then that number starts to get scary. And I didn't like that feeling. And that's when I realized that I didn't like that level of fame or notoriety, and I endeavored and succeeded after that to scale things back in terms of my notoriety, and I've been plateauing around that, pre-trial notoriety level ever since, and I like that. But as a part of the fallout from that peak of notoriety and also just the nature of the trial that I just walked into without any knowledge. I had no idea how passionate people were about Johnny Depp and Amber Heard. I mean, to me, I'm just like, well, they're both actors and God knows what's going on behind the scenes. And I think I've heard little things here and there, but I don't know. And how would we know without video of anything? It's all just hearsay or rumor. I had heard a recording that one of them took, or the both of them took in a conversation. And anyway, so I started to get people making threats to harm me and my family. There were people who were trying to take me down from YouTube or something. And so when I got a notification of this complaint about me, and this would be about 6-9 months later, I figured it must be one of those people who were trying to get me. And because there was a good, 100, 200, 300 people on Reddit or on Twitter or something who were attacking a lot of people that they thought were not having the take that they wanted. And this was coming from both sides. I had Johnny Depp fans that thought I was against Johnny Depp, and I had Amber Heard fans who thought I was against Amber Heard. So I don't know what that says, but again, 99% of people were just like, I thought you were just providing your opinion based on the data before you, and it didn't seem like you were taking sides at all. Anyway.
And just to be clear, we never spoke about any of this stuff.
No. I was just making all these videos and was completely without any legal advice as I was talking. But part of the whole project, because I recorded, I think, a total of 65 hours of content during the trial. Initially, I was just going to record one video, but people were so interested in my opinion on, particularly the forensic psych, because there were a number of forensic psychologists that were on the stand, and I'm trained in forensic psychology, and so I thought I could provide that. Plus, it was kind of fun to revisit that stuff because I don't do that stuff anymore. But anyway, I was editing and being very careful about what I said in the videos because I'm commenting on an actual case and my risk of some kind of lawsuit against me was increased, right, compared to other kind of content I make. So, I was being extremely careful about what I was saying. There were a group of people that were going after people that, content providers that they thought were not in line with their, I can't remember if they were Johnny Depp fans or Amber Heard fans or both, I don't know. But they would actively say and plan in public that they were going to submit complaints about me to the licensing board and others. I wasn't the only one. There was many. They were organizing like, okay, let's all do this kind of a thing. And so I figure it must be from that. And the kinds of things that they were claiming that they would complain about to the licensing board were extreme. These aren't, I don't know what to say. At the very least, they're not educated on the ethics and the law regarding mental health professionals in Washington State. Let's just put it that way. Another way to put it is they're not the sharpest tacks in the box. Mm-hmm. So the kinds of complaints that they were talking about online were that I couldn't call myself a doctor legally because I'm not a medical provider. So when I received this complaint, I figured it was from at least that side of things, and the complaint reads as follows. It's anonymous, one, and it says, this person is an MFT, meaning a marriage and family therapist, and then my license number, which I'll say it's LF 00001679. I was one of the first licensed marriage and family therapists in Washington State, as evidenced of so many zeros at the beginning. This person is a marriage and family therapist and is not a licensed psychologist, but they represent themselves as a psychologist and use the term doctor across their very wide, very public marketing/promotional platforms, their website, YouTube, and they provide a link to the YouTube channel, and Patreon, and they provide a link to the Patreon page. So again, this person is a marriage and family therapist and is not a licensed psychologist, but they represent themselves as a psychologist and use the term doctor across their very wide, very public marketing promotional platforms. So, Fran, I don't know if you can comment on this publicly, but what do you think about that complaint?
In general, you are, if you have a PhD or a PsyD, you are a doctor. And so you can say, I am Dr. whoever, Dr. Smith. That doesn't mean that you're saying you're a psychologist, though. So you can have a PhD in psychology. That doesn't mean you're saying you're a psychologist. To be a psychologist is in this state, and I believe in many states, it's a very specific status that is gained when you have completed a PhD, which can be a PsyD or a PhD or a PsyD, which is a doctorate level accomplishment. And on top of that, you take a certain test. Also, all of your courses have to be, as I understand it, all of your courses have to be accredited in a certain way. And then you have to take a certain test. You have to pass that test. When you have all of those things together and you fulfill the paperwork and pay for the license, then you are a PhD who can call him or herself a psychologist.
Right.
Without that, then you can still be a PhD who practices as a licensed mental health provider, or in your case, LMFT, licensed mental marriage and family therapist. And that's what you do, right? Yeah. So that sounds like it was written by somebody who didn't know all these aspects of what it takes to be a psychologist or what it takes to be licensed. There's also an entity called a school psychologist, which is a master's level education, and that's a whole separate thing as to how they can call themselves.
Right. Ironically, or I don't know, coincidentally, I have done work for schools that I think, I never looked into this because I didn't care, but when this complaint came up, it was, I looked into it just out of curiosity. I think I am considered a psychologist by that school district, by the nature of what I was doing. But I've never called myself a psychologist, one, not because it's just not accurate. Right. I'm trained as a psychologist, and I could be a psychologist, a licensed psychologist, if I were to take the test and pay the fee. But I've been a licensed marriage and family therapist long before I went back to get my doctorate and master's in psychology to be trained as a psychologist. So there just wasn't any benefit to becoming a licensed psychologist that I saw. So I decided not to do that. But yeah, I've never called myself a psychologist. Sometimes people call me a psychologist, and when I have the chance, I'll correct them. I'm not a psychologist. And sometimes I get in fights actually with or conflicts with these people. Like a documentarian group, documentary group will have me as a talking head in their documentary, and they want to, on the title of who I am, they want to say Dr. Kirk, a psychologist, and I'll say I'm not a psychologist. And they'll say, well, what do you mean? I'm like, well, actually, and then, for people outside of our profession, it doesn't make any sense. They've never heard this stuff. It's all very arcane information. Well, it's actually, I'm trained as a psychologist, but I'm a licensed marriage and family therapist. And in order to call yourself, but they're like, well, but you work in psychology, right? Yeah. Well, then you're a psychologist, right? No. Well, you're a professor. How can you be a professor? What are you a professor of? Psychology. Well, and you're not a psychologist? I don't understand. And so I will say, well, I don't know if do you really want me to talk at you for 15 minutes, but here's what you should call me. You can call me a licensed marriage and family therapist. You can call me a therapist. You can call me a mental health professional. You can call me a professor. You can call me a YouTuber, or you can call me the host of psychology. Here's all the things that are true, but you can't call me a psychologist. And this one documentary group were like, well, we're just going to call you a psychologist because that's what the audience will understand. And I'm like, you can't do that. I'll pull out of the whole project if you do that. You understand? Don't do that. If you had done that and didn't tell me, then I wouldn't be able to stop you. But now that we're having the conversation, no, you can't, and I've never said that. So it's not a casual thing to me. And it's not even that. I don't even care. But anyway, so this complaint said that I'm representing myself as a psychologist. So that's kind of interesting. I don't know what they meant by that, because they didn't say that I claimed I was a psychologist. So the whole complaint is based on the fact that I refer to myself as Dr. Kirk Honda. That's the whole complaint.
I'm surprised. Did the Department of Health go to your site to see if it was corroborated?
I don't know. So they later sent me a notification. Actually, so the notification, so I framed it as a badge of honor and put it on my wall. And so I pulled this framed document off my wall just now, and I'm looking at it now, and it's dated in late January of 2023. So I think that if I remember right, I think I received this notification not having known the complaint had been submitted. So I think the complaint was probably in 2022, and then I get...
Well, does it have a case number there? Does it give the year?
It says report number 2023-363.
Yeah, so the 2023 would mean that it was at least filed or accepted in 2023.
Oh, okay. So maybe earlier in January. So by January 31st, they date this letter. They send it to me, and they say, Dear Kirk Honda, the disciplinary authority for marriage and family therapist license credential has received and reviewed a report alleging you committed unprofessional conduct. The report was closed without investigation or disciplinary action. This report will not appear on your provider credential search webpage because no action was taken against your credential. This report is releasable to the public if someone makes a written request for a copy of the record, or I just publicly announce it on the podcast. Let's see. The closure reason for the report is BT, it's some sort of code, based on information provided, no violation of the law occurred. So I think they just looked at the complaint and said, well, he probably just has a doctorate. And he's calling himself doctor.
They probably went to your site and saw that there was nowhere that you called yourself a psychologist.
Right.
And that you had a PhD. You have a PhD, right? Or a PsyD?
I have a PsyD.
You have a PsyD, which qualifies you to call yourself a doctor.
Right.
And so they did, it sounds like they did go to the site and on their own saw that the complaint did not bear fruit. It did not have any reason. There was no reason for them to proceed with it. So that's good.
Yeah.
So you had a complaint, but not an investigation. So did you ever apply to the PDRC? Did you submit a written request for the complaint?
Yes. And that's why I got what I was looking at earlier when I was reading the actual complaint. Yeah. If I remember right, I got this letter. I called you, and I was surprisingly serene about it because, for you've been with clinicians as they deal with these complaints. It's one of the worst moments of our lives.
Yeah, it's terrible.
Personally and professionally. It's one of the scariest, most humiliating, most, horrifying situations. And I had that dread as well my entire career. But when I got this notification without even knowing what the complaint was, this was on the heels of all of that talk online about people coming after me. And I think I had adjusted to the idea that if I ever get a complaint, it 99% likely that it's going to be ridiculous, that it's not going to hold any water, and it might even be evidence of, at the very least, some level of notoriety that I have achieved. and might even be evidence that, I'm shaking the tree a little bit, that I'm not just sitting back and providing bland content without any kind of take. If you don't stick your neck out, then, are you really saying anything? Because if you start saying stuff, it's going to bother some people. And that's not my purpose in life. I'm actually not a fan of that. I mean, everyone's free to do what they want to do. But so I get this letter, and then I called you, and you told me, well, you told me exactly what you just said. And then I submitted that. It's an online form. And then I received this document as a PDF or as some sort of image or something. And then when I read it, I was like, wow, that's even more ridiculous than I thought it was.
And you didn't have the name of the person. It doesn't anywhere give the name?
Right. It specifically says, I want to file an anonymous complaint.
Because I've seen things like that too, where it says, I want to file an anonymous complaint, and then they give their email, which has their name in it. Right.
There's nothing like that. I'm looking at the whole document, yeah.
So there was nothing that gave you that information?
No. And I wouldn't. Even if I did have their information, I don't know if I would look into it. There's enough of these people with public Twitter accounts, it wouldn't be hard to at least find the group of people that in all likelihood this emerged from. But yeah, I remember reaching out to you and being very soothed by what you were telling me. You have a soothing voice anyway, but also the expertise and wisdom that you have, I'm sure is appreciated by a lot of people. You're just like, well, let's look at this. This is a thing, and we'll get our way through this, and here's what likely will happen. Because, for us therapists, particularly people that don't know how this process works, even though it's not rational, and I'm sure people wouldn't consciously think this, but the way that it definitely feels, and I know that my colleagues and my students and supervisees definitely feel this way, and is that even if the complaint doesn't have any merit, the therapy police are going to show up and literally just throw you in prison. It just feels like if anyone makes a complaint against you, you'll lose your license, you'll be humiliated, and you'll literally have some kind of major consequence to the freedoms of your life. Most therapists don't consciously believe that, but the way that we react to even just the prospect of a complaint being submitted against us, it's utterly just panic-inducing for us.
Well, it is horrible. I mean, it's horrifying, really, because, I mean, I want to say all the therapists I know, but let's just say virtually all the therapists I know are very conscientious people. They're highly ethically driven. They very much want to help people. They're a very and they tend to run anxious, and so which goes along with a lot of those characteristics. And so their goal is to help and to do it well and to not create problems. So to hear that somebody has disliked them enough that they would go to the Department of Health rather than come to them and talk about it is a very upsetting feeling. The way that I work with people when they have a complaint is I tell them we can do this one of two ways. Well, first of all, I explain the process so that they at least know. And their big fear is that they're going to lose their license, which often for the kind of thing that they're being looked at, most of the time that would not be the case. But I give them a sense of how it can go and how they can ease the pain of it if possible. And then also I'll say to them, we can do this one of two ways. We can either just stick with what the problem is and refer to nothing else, or we can talk about what the problem is, but also talk about if this were to happen in the future, here's how you could do it better. But I say to people specifically, I don't want you to feel that that's critical. I don't want you to feel that I'm, criticizing you or shaming you or anything like that. It's just that most of my clients feel that that's very empowering, because then going forward, they have an even better sense of what the standard of care is and how they can do that. So basically, it's particularly when they choose that second path, and most of them do. I've only had 2 people who have not wanted to do it that way. But when they choose that second path, they've often told me that they come out of it feeling very empowered and feeling that they learned something that they didn't learn in school, in their master's programs or PhD programs. And so they feel, and we try to do it with a sense of humor, because there are some things that can feel absurd or funny. And people feel empowered and they feel stronger going forward. And I've had a lot of people just say that it's just helped them. Not that they are happy that they got a complaint, but that they felt that I was able to help them through it in a really positive way.
Yeah, I mean, it's not an explicit goal as far as I know, but the complaint process, as it usually plays out anecdotally in my experience, it is an opportunity for education and ironing out some of the wrinkles of one's education or understanding or routines. In my experience, most clinicians would do the safe, ethical thing if they just knew what it was. Mm-hmm. And so much needs to be known, and there's so little time in graduate school, even though you can be in a doctoral program for 8 years, but that is just not enough time to cover all the things that you need to cover. And in my experience, the ethics, legal professors, it's a roll of the dice as to whether or not they know what they're even talking about.
Oh, wow.
Yeah. I've known a lot of ethics professors. I've hired ethics professors and found out some of the things that they were talking about and thought, wow. But then the other thing is the adjudication of these ethics complaints are sometimes adjudicated by people that also don't know what they're what they're talking about, and your practice or your future is in their hands. And because these licensing boards or judges is another thing. There's a varying degree of expertise and agenda, I suppose, that a judge would have as in a situation where they're being sued, for example, in court. But with licensing boards, correct me if I'm wrong, they're usually clinicians that are volunteering, right?
Licensing boards, as I understand it, there are clinicians, but then there are also people who are licensed in some other area who might be part of the decision-making process. And then I believe that they also have non-professionals, members of the public, who are part of the board.
And these are volunteers?
I believe so, yes.
Yeah. And how many are on a board? Is it?
That I'm not clear. I'm not sure. It's easy enough to look up. I think around 6 to 10 people, but I'm not sure.
Yeah. In my head, it's like 6 to 10 that are available, and each case is assigned to like 3 to 5 or something. Does that sound about right?
Yeah. No, I don't know. I know that they also have lawyers who work for the Department of Health, and I believe that each case is also vetted through a lawyer to make sure that the legal aspects
But in terms of the standard of care questions, which is often what's being looked at when it comes to the complaint, the clinicians are the ones who are reviewing that information, that
and sometimes they might bring in somebody from another whose expertise might be involved.
Okay.
Like if somebody works with dialectical behavioral therapy, DBT, they might bring somebody in who works with that, because that's some of the tenets of dialectical behavioral therapy are very different from other forms of therapy.
Right. So the way that this would have looked is they meet the board, and on the docket are a number of new complaints, and they come across mine, which is pretty short. It's just one long run-on sentence. And maybe they go to my website or the websites that were provided in the complaint itself, and they, as a part of my bio, it says that I have a doctorate, and they're like, well, okay, end of that question, and we'll just file this under this code that they provide, BT, based on the information provided, no violation of the law occurred. And then it just gets into a computer system, and then this letter gets spat out and sent to me. Does that sound about right?
Yeah, and then there are other things that would happen. For instance, if there had been a finding, if there had been some sort of investigation, they would have asked you a bunch of questions. You would have answered the questions. If those questions, if on the basis of your answers to those questions, they decide that there's no evidence to support the allegation, or for some other reason they're going to close the case, then on the website, the Department of Health, where you can go and do a credential search on a provider, on that website, if you were to ask if there has ever been an action, it will say no. Even though there had been, you can get the record of it that there had been a request or a complaint, but there was no action on the part of the Department of Health against you. If there had been an action, and that can include what's called a STID, which stands for Stipulation to Informal Disposition. If there had been something, then it would say yes, and then a person could click on it and they could see what the action was.
Right. And in case people don't know, the government, the state government, is asked by the people to monitor various different professionals to make sure that they're not likely to harm the public, right? And so they have to vet these professionals at first to provide licensing and then also monitoring of that licensing. So if you are a mental health provider or a medical provider, or you are, I'm guessing there are licensing in construction or in other kinds of, meat packing or restaurant ownership, the government can take away your license or can put stipulations on your license to correct for problematic behavior to protect the public. And that's what this is all about.
Yeah, that's the idea.
Yeah. Let me ask you this. I've reviewed a number of cases, both prominent and not prominent, because my malpractice every once in a while sends out these case briefs detailing a case that was involved in my malpractice insurance for another clinician. And in both the prominent and the non-prominent cases where it is found by the licensing boards of various state governments that the clinician was in violation, the consequences, in my mind, are often far below what I would expect and hope the consequences would be. For example, if someone were to have sex with their client, or if someone were to commit fraud for 5 years or something, or if someone were, there's this one case where this counselor had been found to have committed fraud, I think regarding like an insurance scam of some sort, and had their license put on probation, and they were told they can't operate as a mental health clinician until they get their license back in 1 or 2 years or something. And this clinician just quietly changed their disclosure statement and quietly asked all their clients to sign it and never told them what was different about this new disclosure statement. And to me, two strikes, you're out. I mean, there's something wrong with you. And, and this is only the tip of the iceberg. And so they should have their license permanently removed. And there's plenty of other jobs they can have. You're not stripping them of their ability to pay their bills or something. There's a lot of other possible jobs you can have. And so that's just one example. But often it's just a slap on the wrist, or another clinician will do something pretty egregious, become, like I'm trying to remember the details, but the counselor had hired their client as a babysitter, and the client had borderline personality or something, and I can't remember all the details, but it, obviously spins out of control complaint. And I'm thinking, at the very least, there should be a lot of training required, a lot of supervision required, and maybe some probation. And they'll just provide like a $2,000 fine and like 2 days of continuing education. And I'm thinking, that's it? That one isn't really reflective of what I would assume would happen. And how is this protecting the public? Because these individuals are rare. The kinds of things that will get you in big trouble is rare. And therefore, if you come down hard as a licensing board on these people, you're not going to strip the public, because that's always the tension. It's like, well, if we're really strict, then we will limit the amount of professionals out there that can actually help people, right? Mm-hmm. But if it's, 1 in 100,000 of clinicians, or I don't know, some low percentage that are crossing those lines and being caught, then I don't think that that's a concern. Am I wrong in being upset at a lot of licensing boards for not being stricter?
Well, first of all, I just want to go back to one thing about your case. I just want to say that they probably could have also listened to your podcasts.
Okay.
They might have sat and listened to your podcast and see how you referred to yourself. That would be another thing.
Right.
So, okay.
How I introduce myself.
Yeah. Mm-hmm. Okay. So going back to this other question, it's an interesting question. Like, what is the Department of Health there for? My understanding is that they're there to protect the public. My understanding is that they're not there to punish, but to educate so that you can protect the public. However, the restrictions are very broad, they're very broad, and there's unless it's against the law, they can. I think the DOH has the liberty, or the secretary of the DOH or the executive director has the liberty to handle things in the way that they think best, without particulars. So they have a lot of discretion. But having said that, if that is the whole question: is it disciplinary? Is it educative? How do we best protect the public? And for people who have sex with their clients, I just gave a talk on having sex with clients, and you'd be surprised. I mean, the statistics, I don't know exactly the numbers, but having sex with clients is considered to be high among the risks that can occur, mm-hmm. which astounds me. I will say, I used to think of the codes of ethics as these sort of aspirational, impossible goals to meet. And the more I do this work, the more I now think of the codes of ethics as somebody who's coming to you from the future, who's seen it all, who's like gesticulating wildly, trying to tell you, no, this is a real concern, pay attention here. Because the way things can turn around, the business of dual roles, multiple roles, and conflicts of interest, you think everything's fine, and I talk to the client about it, and they're good with it, and so you sort of move ahead with whatever the dual role might be.
Right.
And then it just falls apart in your face.
Yeah, I mean, even having sex with a client, which I'm sure all the listeners understand the problems with that. But, like if you're driving a car and you see a cliff coming up, you clearly see the potential horrible future of continuing to drive forward mm-hmm. without turning or braking. But when it comes to these ethical guidelines, concerns, codes, as you say, it's this person in the future gesticulating wildly, like you don't understand. Like right. there's a potential horrible thing, and when it comes to having sex with your client, it's similar. Again, I'm sure all the listeners fully physically feel the danger of that, but it's not like you can see that cliff. The client and the therapist want to have sex with each other. They like each other. They're attracted to each other, and they want to do that. And so they do that, and there's no immediate consequence, right? There can be, of course, but sometimes there's not. And, you're in love, or you're in lust, or everyone's consenting, everyone's adults. And there's this ethical code or guideline in the distance, or law in some situations.
There's law, yeah. Here.
Yeah, in Washington. Is it across the United States?
I was looking this up. I believe that every state throughout the country has a prohibition an absolute prohibition on having sex with a current client.
Right.
There are some rules that make it seem as though if you wait 2 years, then it's okay to proceed with a relationship. But it also, here in Washington, it also says that if there should be harm to the client, that it'll be up to the therapist to show that there was no harm, which is very difficult to show if somebody's saying that they've been harmed, even if it's 4 or 5 years later. And in Washington, there is another whack that my reading of it is that is not as extreme as they employ it, as they apply it to be, but they basically apply it to say that you can never have sex with a current client and never, ever, ever forget it, have sex with a former client. Even I don't quite read it that way, but that's the way that they apply it. And so that's what it is.
Yeah. Every profession has a different waiting period and slightly different way of wording it, but every state has a different wording of law. So there's two different things to consider there.
But in Washington, it's never.
Interesting.
Forget it. You will never
regardless
get it.
of profession.
And not only that, but in Washington, if a person is found to have had sexual misconduct, had sexual misconduct, which is a particular statute and all that, and whack, if they have been found with a sanction attached to that name, then by statute, afterwards, they have to give every client that they have going forward, both current clients and new clients, they have to show them the sanction. They have to let them read it, and the person has to, I believe, sign off on it, so that I can only imagine that it will have a hugely chilling effect on their practice.
Yeah, almost like a registered sex offender or something.
Kind of. Well, it feels that way. I mean, to have to extend that, because everybody is able to go to the DOH site and see if there's been a finding against a person.
But almost no one either does that or even knows that they can.
Right. But in this case, it's the therapist who has to bring this information to the client and show it to them.
Interesting.
So I would imagine that it would have a chilling effect on maybe if there's a population of people who have had sex offenses or sexual sanctions for sexual activities, maybe they would want to have this therapist. They might feel more comfortable, like he or she would understand better. But otherwise, in general, I think it would be quite difficult.
Yeah. Yeah, and I have found in reviewing these cases, and you tell me if this is your experience, which is a lot more extensive than mine, that when you discover that a clinician has violated, a fairly significant standard of practice or ethical code or even law, that it's just the tip of the iceberg, that they, in all likelihood, are violating so many different aspects of the standard of practice or of careful provision of clinical services. Like I'll be reviewing one of these briefs by my malpractice, and the initial problem will be noticed regarding a dual relationship. Clinician will, say, hire their client as a babysitter for their kids or something, and that's pretty far across the line. And what will be found once the investigation begins, that was just one of several things. Another thing that often follows that is that their paperwork is atrocious.
Yeah.
And they something that will follow that is they're doing this with other clients. It's just the tip of the iceberg. So when because the argument against the mandatory disclosure of new clients that you have had sex with a client before is to say, well, what if they're reformed, or isn't that a little draconian? Well, to me, if I were to see a therapist and I was given that notification, I wouldn't go to them, because even if it was 15 years ago, there's something about them that raises not only, because I would assume and hope that they would probably never have sex with our client because they've been punished. That's one of the things to think about. But there's probably something askew with their personality or cognitive abilities that results in dozens, hundreds of violations that are not being detected or not being reported on or something. And I just don't want to take my chances with a clinician like that, even if they show evidence that they have reformed in that one area. Does that make sense?
Well, it's an interesting situation because, first of all, the person who usually reports the therapist is, guess who?
In the cases of sex with clients, the client.
Yeah.
Yeah.
So right, it's inevitable that, many, many times it's the client who reports the therapist. Next to that, it's the client's partner or former partner. And then after that, it's the therapists of the former client and or the former client's former partner.
Right. The client goes to another therapist,
Right.
and then that therapist hears and reports. Yeah.
Right, exactly.
Yeah.
So, and what's so interesting is that for both of them at the time, if you talk to them about it, it seemed like a good idea at the time. Like for all the things that they can look at, they feel that it seems like a good idea. So, which points to your point about judgment, that you're really underneath it all thinking about their judgment, and that you might not want to see somebody for that reason because it has implications about their judgment.
But do you find that where there's smoke, there's fire, in that there's, or, it's the tip of the iceberg in terms of the violations that are discovered upon and investigating even a little bit below the surface?
Well, you made an interesting point before when you said about the documentation. Like, documentation often becomes an issue, that people don't keep documentation because they themselves don't. For instance, if they're going to maintain that having sex with their client, I mean, this is a little. This is a little attenuated right now, but they might say that having sex with their client is that actually had clinical value. Well, if there was clinical value, did they take notes on it? No. And it just generally turns out that the note taking is very poor because it's somewhat evasive, I guess you could say. And so that there usually are other aspects to it. Now, in terms of why this kind of thing happens, it's possible that there's a kind of biological piece to it, which is that gratitude. You know how we talk about oxytocin and oxytocin creating connection with people, so that when somebody has a baby, that the whole that the process of feeding the baby, breastfeeding in particular, massage also creates oxytocin. So there's a feeling of connection. As it turns out, gratitude also creates oxytocin in the brain and in the body. And so, and when you think about the dynamic of a therapy situation, often for the therapist, first of all, the therapists have often lived their lives being, very analytical and thinking about problems all the time, or thinking about relationships. And a lot of time people will say that the experience they have in their lives is that they're being told that they're too dramatic, or that they perseverate over things. Like, can't you just let it go? And for the clients also, they have a problem that they can't fix themselves, or that their families haven't been able to help them with. So they go to a therapist. And for the first time, they find themselves in a relationship, in a conversation, where the therapist is listening and the client feels grateful for what the therapist has to say. And so the oxytocin is flying around. And so it does create a kind of warm, and to say loving is possible, it does create that. The thing is that the therapist is supposed to have a handle on it at all times. And is that, I mean, I'll say to clients, have you ever had a client fall in love with you? And if they say no, I'll say to them, it's very possible that it will happen in some time in your practice, and you need to be prepared for it, because you feel like you can feel like a deer in the headlights. You don't know what to say, and those moments are really important. To be able to say to somebody, sometimes this happens in therapy. It can be a transference effect, or however you want to explain it, but that you are not going to have an affair with this person. You are not going to engage in a relationship. You are not going to end the therapy so that you can now start dating and quote unquote see where it goes. And but that's not taught so much, I'm told, in schools anymore. And that's why my whole approach, not to go back to this, but my whole approach with the disclosure form is that you put this stuff in it. That you have a section on, it's not required by law, but you have a section on dual roles. And you say, I am not going to engage in dual roles with my clients. I do not engage in business relationships. I do not engage in personal relationships, financial relationships, or romantic relationships. It can be a little bit awkward to say to somebody, I'm not going to have sex with you. I'm not going to fall in love with you on the first meeting. But it's a little bit funny, to say that. And it's much better, in my opinion, than having to say it when the person is, very much really in love with you on some level. I'm putting that in quotes, but on some level, and very seriously wanting to have that conversation. If you've already had it, even in a passing way, or even if you didn't, if for some reason you didn't discuss it, but it's there in your disclosure form, it's much easier to say to the person, I don't know if you remember, but we actually discussed this on the first day, and it would have been written in, sensitive but professional language, and you can point to it and you can say, I told you that day, this kind of thing happens. Don't feel bad about it. And we can talk about it. It's called a transference, or however you want to call it. But no, that's not possible.
Yeah.
It's not possible.
Yeah. In my own experience with disclosure statements helping clinicians and the therapy is along the lines of what you're talking about. And this actually applies to when I was at the university more actively, and also when I was program director and we had a student handbook, which is kind of like a disclosure statement to the students in a way, that I found that for myself, no one told me to do it this way, but I developed the handbook, the student handbook, and the disclosure statement as a reminder of what I was supposed to do. Having sex with a client, I don't need a reminder not to have sex with a client, but there's so many little nuances of confidentiality and mandated reporting and other kinds of things that, because, the average therapist doesn't think about ethics and the law very often because they learn about it early in their career. And we just don't really run into a lot of situations that require us to relearn a lot of things. It's kind of a rare, if we all just follow the regular routine of being a therapist, it's just not very often where we run into, unless you're working with particular kinds of populations, we don't usually run into mandated reporting questions or huge ethical dilemmas. But when they do happen, it's important that we understand. So, you can go for 5 or 10 years without ever needing really to revisit the whole topic. And out in those intervening years, you might have completely forgotten everything that you learned, which might have not been sufficient to begin with. And so I used my disclosure statement as a way to provide a reference for myself.
Yeah.
I would be faced with, for example, a mandated reporting situation, and I would go to my own disclosure statement because I knew that I vetted that very thoroughly. And the laws and the case laws are always changing, and the rumors on Facebook among clinicians are always wrong or usually wrong. And because there's groups of therapists on Facebook that are say like, is this ethical? And it's like, usually the comment section is just riddled with ridiculousness. And we just need that. And so the student handbook was the same thing. Especially with a educational program in marriage and family therapy, there are just so many nuances and literal laws. There are laws that dictate how educational institutions are supposed to operate, in terms of accreditation, but also just in terms, there's confidentiality laws for students, that kind of stuff.
Right. FERPA.
Yeah. So having all those nuances disclosed to the students, because we should, and I think have to, but also for the professors to be able to look to it, and also my subordinate professors that I'm, of which there were dozens that I don't have time to monitor everything that they're doing. I say, look in the handbook before you do X, Y, and Z, because it's all there. And so, not having sex with a client, but also the practice of going over the key, it's not realistic that we're going to read word for word the disclosure statement to our clients every time we meet with them for the first time, because that would take a long time. But there are certain sections that you should maybe not read word for word, but you should verbally explain, especially I think the confidentiality section and maybe the dual relationship, like if you bump into them in public, that kind of stuff. That's not really dual relationship, but it's kind of in that category. That and also where to complain, right? That's in there. And I this is the training that I provide my trainees is, okay, here's your disclosure statement, and here are the sections that you need to, in common language, explain to people before they sign. And not only should the clients hear that from you and understand it, because they might just sign it without really reading it, but also every time you say it, you're reminding yourself of these things, which I think are important, because if you don't watch out, you'll slowly drift into complacency and you'll harm someone, and you could be consequenced for that, So that's always my take on that. But let's take a break. When we get back, let's talk about that case that...
Okay.
All right, we're back from the break. So how do you want to start talking about this case?
Just to give a little bit of context, we were talking about when does the responsibility to report, when does that start or end? Does it ever end? Or are you, as a therapist, a licensed therapist, are you always responsible to report for child abuse?
Right. Meaning if you're socializing with your friends
right.
and you hear something that indicates that a child or a dependent adult is being harmed, are you even mandated in those situations to submit a report to the government?
Right.
And I remember hearing in the psychology world anyway, I'd have to look at my notes actually, because, but from my memory, the legal experts were saying that it's unclear, but they believed that we were not required when we were off the clock, meaning we were not in the capacity of our professional activities, which can sometimes have a bit of a gray zone. But they were also saying, the experts that I remember talking with like 15 years ago, that you probably should seek legal counsel because some scenarios might have nuance to it. Plus, there might be case precedent that you haven't been made aware of. And of course, every jurisdiction might have different requirements to that. So this case that you're going to present is along those lines. It tests that question.
Right. And also, knowing that when you mentioned some of the Facebook groups that people use, which can be great, for people to have community.
Can you pull the mic closer to you?
Oh. Which can be great for people to have community. But on the other hand, sometimes people, they don't realize it, but they're giving legal advice. And that's kind of dangerous. And then also sometimes people think that they've had the exact same situation, so you should do exactly what I did and you will have the exact same result. And that doesn't work out that way, because sometimes if there's one factor that's different, it goes a completely different way.
Yeah. And it takes a legal expert to even know what to ask to determine those differences.
Right.
Yeah, I remember a case, there was... to a broader extent, I reviewed on the podcast 2 different cases of students who had been kicked out of a program because they were refusing to work with gay clients.
Wow. And
in one scenario, so from the surface, it looked like the cases were essentially the same. And so in the first scenario, in the first case, the judge or the jury, the trier of fact, found that the program was not negligent or harmful or outside of the law in kicking out the student. Mm-hmm. And so there's a second case where it looked very similar and the program had kicked the student out. And it was like, oh, well, open and shut case. It's the same as, but there was a significant difference that you had to be a legal expert or an expert in this area to even detect that it was a difference or even know to ask that question. And it made that second case actually result in the program being found. I don't know the exact, that the ruling was against the program. Mm-hmm. And yeah, I remember thinking as a non-expert, wow, I wouldn't have predicted that. That's interesting. So that's what you're talking about.
Yeah. And it's interesting when that kind of thing happens to look at the 2 cases and to try to understand on what basis they make that distinction. Sometimes if it's a different judge, that can make a difference.
Right.
People will often ask, "Is this legal?" And I have a colleague who basically says you'll only know when it's legal if it's gone to a court, and then the court makes the decision, and then which way it goes.
And you tell me if this is right or wrong. I think that in our field, it's particularly ambiguous because it's so rarely taken to court. our profession. We don't experience a lot of complaints. There's not many of us compared to like the medical profession, for example, and it's rarely put to the test. So there's a lot of cases that might seem fairly run-of-the-mill or fundamental might not have any case precedent. So there's that. Plus, I have found and seen cases where judges, because of the rarity of these coming across their docket, they sometimes have trouble ruling because they're just not familiar with the field of mental health the way they might be familiar with other fields like the medical profession or something. Right. Is that true that it's just kind of rare that these questions are even run up the chain?
Well, one of the things, I mean, this happens to be a Superior Court case that went to the Supreme Court that we're going to talk about. But when we were just talking before about DOH cases, part of the thing is that the Department of Health is not the judiciary. It's part of the legal structure called administrative law. And so they make determinations which are not made within a court system. They're not made in the judiciary system. As I said, it's the administrative piece. So as lawyers and as a community, we find ourselves trying to understand how they have ruled before and to make sense of it, and then to provide advice or to provide insight on the basis of those things. But often those things might not have had the same result if it went through a court. So you're kind of trying to find this balance between what's practical. I mean, if this is how they see the problem, then okay. But then you can accept it on that level. That situation that I was saying where I think that the statute that the WAC does not actually say how it's interpreted, how the board interprets it. If somebody wanted to fight that, they would have to exhaust the remedies within the administrative arm. So they would have to go to a hearing. They'd have to fight whatever result they got, even if it was a relatively good result. They'd have to reject it and take it to a hearing. And then having exhausted that remedy, the hearing is called a remedy. So having exhausted that, then they could go to the Superior Court and see, and then it might be appealed. Whoever wins, it might be appealed. So we're talking hundreds of thousands of dollars to do that. And it's very time consuming. It might be years before the case is now off the back of, where the person can set it aside. It'll be years that it'll be in their lives, which means that they might be thrown off of panels, or insurance companies might not accept their cases anymore. So it gets very, very extenuated.
Meaning that since there's so many barriers to running it up those chains, the vast majority of people just wouldn't bother. So there's not a lot of guidance. Like I think about Tarasoff, for example. That was a California case, right?
Right.
And all the other states in the union followed it because they just figured that it was likely to be ruled similarly in their jurisdiction, even though there hadn't been a case precedent, perhaps in their jurisdiction. So that just points to how rare it is that in a particular jurisdiction that these kinds of, I think, fundamental questions are even put to the test. Anyway, so what's the beginning of this case?
So if you, I don't know if most people know this, but if you if you are aware or have reason to believe that a child has been abused or neglected, or have reason to believe that a vulnerable person has been abused or neglected, or financially abused and neglected in various ways, if you become aware of that, you're supposed to make a report. One WAC says immediately, and then the statute says at the first opportunity, but in no case longer than 48 hours.
Right. If you're a mandated reporter. If you're a mental health clinician or a medical professional or a teacher, or what are the other professions?
Well, it says any provider. So if you fail to do that, then you have, it says in the statute that you could be, that you've committed a gross misdemeanor. A gross misdemeanor, you could end up in jail for. I mean, domestic violence could be an example of gross you're basically in the same boat as somebody who's committed domestic violence, conceivably. So it's a big deal. So there's always this question: do you disclose something that should be confidential, which the client would feel you violated their confidentiality, or do you disclose this information on the basis of the legal requirement? So that's the question. And then in this case, the question, there was a situation where a mother who was a teacher was charged with the failure to comply with the mandatory reporting law that requires specified professionals to report incidents of child abuse when they have reasonable cause to believe that a child has suffered abuse or neglect.
So she was charged by the prosecutor of a crime.
Yes, this was a state. Yes, this was the state versus.
So this isn't a licensing thing, and she's a teacher anyway. So, but I'm guessing they have a licensing procedure as well. So this woman, this teacher, was charged with a crime, the gross misdemeanor of not adhering to the mandated reporting requirement.
Right. I should go back and see exactly what the crime is, but I mean, how many counts of it or how that worked out. I'm not sure exactly about that. But so in this case, it says that she received notice of child abuse from her 3 daughters, alleging that they were being touched inappropriately within the home by their stepfather, meaning their mother's new husband, who was not their father, but she did not make an immediate report. So at issue is whether the mother's employment status as a teacher required her to report the alleged abuse of her own children, who were not her students, when the abuse occurred within the home and was perpetuated by another family member. So there are all these, how we were just talking about, somebody else might think it's the exact same case. I mean, there are all these variations here. Like she's a teacher who is a mandated reporter. The report that she heard was not at home. It was not in her capacity as a teacher. It was her daughters that told her this in the home, and she was not their teacher. It might have been a different result, for instance, if she were their teacher and she found out about this in the home, but we don't know that.
Right. It's kind of confusing, but I think the devil's in the details. That, from my memory, you were telling me that, and the reason why I wanted to talk about this on the podcast is because I was thinking, wow, what an interesting case. So you have this teacher who is at home, and she has a daughter who is attending the school that she teaches at. And she's at home with her daughter, and the daughter had invited some of her friends over to her house. So you have the teacher at home, right?
No, there's not. So I'm not sure about whether the students whether they go to the same school as where she teaches, but these weren't girls coming over their house. It was the 3 daughters who lived there.
Her daughters?
Her 3 daughters.
And they were talking about friends of theirs that were being abused?
No, they were talking about themselves.
So her own daughters were talking about being abused themselves.
Being touched inappropriately.
By
by their stepfather, their mother's husband.
Oh. So that is different from what I remember. So her current husband, who lived with her, the teacher, okay. So she is learning that her own 3 daughters are being sexually abused, potentially by her own husband, the stepfather. Okay, that is very different from my memory. From my memory, I thought it was that some guests had told the teacher mother that they were being abused in their home, which was, across town or something. Okay.
Oh, no. That would be, yeah.
Well, but it's essentially the same question, which is that under normal circumstances, a spouse is not required by law. Now, hopefully, morally speaking, if you are a parent and you hear about your children being sexually abused potentially by your spouse, you would take action of some sort, maybe even making a report to Child Protective Services. But you're not mandated by law to make a report within a certain time frame. But if you're a mandated reporter, then the question is raised. Are you required in this situation when you are technically off duty, you know?
Well, when the report is made to you when it's not related to your identity as a teacher.
Right.
Right. And because also, the law isn't that, for instance, that you hear that your client was abused. The way that the law is written is that it says if you have reasonable cause to believe that a child has suffered abuse or neglect.
Right.
So it could be anybody telling you about any child.
Right. Yeah. If I have a client that tells me that they have a friend or they know someone that is being abused or abusing someone, then I am mandated to report that. I'm not mandated to investigate it and do some sleuthing around, like if the client only knows the first name of the kid and doesn't know the address, I'm not pressed to press my client to give me that information. I'm just required to provide whatever information I heard to CPS, even if it's limited. It's CPS's job to sleuth around and figure it out.
And another thing people often don't know is that if this is a child has been abused or neglected, has suffered abuse or neglect. So if the child is now grown and can fend for themselves, you don't have to report that abuse. However, if it turns out that the person who abused that person when they were a child, like let's say a 20-year-old is telling you that 10 years ago the person was abused. And so the person's 20, so you don't have to report it. But if it turns out that the person who abused this person when she was 10, that person still has control over and access to children, then you would have to report it.
Right. Yeah. The whole mandated reporting requirement or culture or expectation is based on preventing future harm of children and dependent adults.
Right.
It's not, in essence, supposed to punish people for doing things in the past. It's trying to prevent child abuse from occurring and abuse to dependent adults. So if there is reason to believe or not reasons to not believe that the perpetrator is potentially at risk of harming kids in the future, if I hear from a client, say in the example that you gave, I have a 20-year-old client who says 10 years ago when she was 10, she was abused by an uncle or something. And I am not required to make the report based on the age of the client at this point. If they were 17 when they told me, or if they were 10 when they told me, then I do have to report it. But by the fact that they're 20 now, I'm not mandated by that angle. But let's say I ask the question of like, okay, well, does your uncle have access to kids? And my client says, I don't know. Or maybe, or I don't think so, or whatever. Then there's still that question mark, and I still need to make a report because that, or, even if, sometimes you'll have a 65-year-old client that will tell me that they were abused when they were 10 and they've lost touch with the abuser and they might not even know if the abuser is alive. But unless there's a clear indication that the perpetrator is no longer at risk of harming children, then we just have to, err on the side of caution.
I'm not sure about that. It might err. I'm not sure if you have to assume that in a case, if you want to then get a release of information for the person to say that it's all right to report something, but I'm not sure if you have the duty to figure out if that person is still has access if you don't have reason to believe that the
so I drilled down on this very specifically with CPS themselves. And what they told me, and this is, again, 15 years ago when I was more concerned about this because I was supervising so many people, they said that the law is unclear. It doesn't say either way.
Right.
So if it doesn't say either way, then you might actually be required. So you need to know that you might be required. But are we going to take action against you if it comes out that, in the off chance, say that I have a 60-year-old client that told me that she was abused when she was 10 by her uncle, and I don't make a report about the uncle, and then it's found out that the uncle had abused someone in the past that disclosure to me, and somehow CPS or the law finds out that this 60-year-old client 50 years later had told me about it. Would CPS or the prosecutor come after me? What CPS was telling me was like, that's extremely unlikely, that even though by the letter of the law you aren't protected from not making that disclosure, it's almost impossible to conceive of the law and CPS coming after you. But there isn't a provision in the law that exonerates you from I don't know if that's the right term, but it releases you from the requirement. So it's a lot of stuff like that,
Right. I mean, the law references that, and it does, I don't have it in front of me, but it does say that if it basically explains it the way that I had said it, that if the person is still in charge of children, then it should be reported, or children or elders. I'm trying to see if I can find it, but...
Well, particularly if they're still in charge of children, right? And
if they are still if you know that, then
but an uncle or a aunt or a retired teacher or something, how do you know? If a perpetrator will find a way, right? A neighbor or a friend or something. So a lot of disclosures are told to us along those lines. It's a family member or a friend or, that sort of stuff. So,
right.
But I'm not up to date on the current case law on that. But anyway, so with this mother, I'm going to ask questions to kind of fill in the gaps. So she is told by her 3 daughters that her current husband has potentially sexually abused the 3 daughters. And
I think there might have been one of them in particular, but basically
one daughter in particular.
Yeah.
Do we know what she did after? We know that she didn't make a report, but to CPS. But what did she do?
I believe. Well, and it made the point of saying that she had known about this since 2015, which was a year or two before it finally was exposed. Pardon the expression, but because then they told their pastor, or the girl told her pastor.
In 2017?
And it was the pastor who reported it.
Okay. But do we know what the mother had done prior to, between 2015 and 2017? Did she do anything?
There was nothing that was articulated
in the
that
report.
I saw. Yeah.
Okay. So she might have done a lot. She might have done nothing. I was just curious. So then,
well, except the point was that she did not report it.
Right. But she might have taken a lot of measures.
Yeah, possibly.
To protect the kids, or she might have done nothing. We just don't know. Mm-hmm. So then a pastor hears from one of the kids, and the pastor makes a mandated report or a report, and then CPS starts looking into it. I'm just sort of assuming. And then they interview the kids, and the kids say the full story, or as much as they're going to say, or at least one of the kids. And it is disclosed to CPS. Well, we told our mom 2 years ago, and then CPS looks into it, and maybe the mom even admits to that. Yeah, they told me. And then they find out, oh, well, you're a teacher, you're a mandated reporter. And then they inform the prosecutor, and then the prosecutor charges the mother.
Well, what you're describing is generally possibly how it might have gone.
We just don't know.
I can't say that. Yeah, right. I can't say that I've read those facts. But
based on the facts presented.
That could be an example of how it would have proceeded.
But we do know that she was charged, the mother.
Yeah.
And then what happens?
So all 3 of the girls told their mother about the stepfather's alleged abuse as early as early in January 2015, and all of the alleged abuse had occurred at the home. So then the state charged her with 3 counts of failure to comply with the mandatory reporting applicable to her as a professional school personnel. That's in part of that statute.
Does that seem strange that they would have charged her?
Does it seem strange?
Yeah, because I'm not an expert, but I would imagine a prosecutor would ask a question as to whether or not they were still mandated to report if they hear things at home. It seems like a punitive thing, like they were trying to grasp for some way of getting the mom or something. I mean, we don't know the motivation, but
I mean, often what goes on with these things. So first of all, I don't know if there was a DOH or a Department of Education inquiry made first. Often that's what happens, just so that they can feel out which way it'll go. But we don't see the whole story in these things. I mean, like I've seen various write-ups of DOH cases, which isn't at all. Sometimes there might be important facts that the telling of it would afford that don't necessarily make it into the final record.
right.
So
but it's hard to imagine a detail, because I've never heard of a case like this, but my understanding of what I would imagine that a prosecutor would think about would be that, well, the disclosure happened at home. The disclosure is about her own husband, and she is not the teacher of her own daughters, so she's not operating as a professional, and therefore the mandated reporting requirement isn't at play. We can potentially look to the mother as negligent or something. I don't know what kind of prosecution could occur along those lines, but she's not the perpetrator.
Well, you're saying that, but because you have the advantage of this case, or maybe that's just always been your view of it.
Yeah.
But this has been a big, like if you're at a party and someone is telling you, oh, I almost couldn't come, but the only way I was able to come to the party was that I locked my girls in the house, and I'm sure they'll be fine. And they don't know I'm gone, but they're asleep. So,
And as a mandated reporter,
and you're at a party, and now you just heard this thing from someone you don't even know, or
right.
someone who's maybe your best friend. I don't know, but you've now just heard that these children have been left alone in a locked house.
right?
And if there were a problem, they couldn't get out.
Yeah, I see what you're saying.
But these are and I've seen people. I've been at gatherings where people are talking about themselves, and the mental health providers will stand up and say, I just want you to know I can't listen to anything that has to do with, and they'll give the topics, abuse or self-harm,
Right.
and they'll absent them. So they'll say to people, if you need to talk about that, please let me know so I'll leave the room.
Well, we have to take a break, so let's take a quick break, and when we get back, let's continue, and you can tell us where this case ended up.
Yeah, okay.
Okay, so we're back from the break.
Oh.
Fran, tell us what happened.
Well, so basically what happened was that the state, that it had been dismissed at the trial court level. The trial judge agreed and dismissed the charges. Agreed with the
defendant.
The defendant. She had filed a motion to dismiss the charges, arguing that the statute did not apply to her in this case because her daughters were not her students, and because she learned about the alleged abuse in her parental role while she was in her home, not as a teacher. So the trial judge agreed, and they basically dismissed the charges.
That kind of sounds like she might be alluding to a potential requirement if she were at school and her daughter came to her as a mother-daughter relationship, but she was at school talking to a student, that she might be required. But that's
right,
not.
So she's making that distinction. She's bringing about every reason why she would not be thinking about
Right.
it in her role as a. But see, the thing is does that role ever change? That's the big question that people have.
Yeah.
In any case, the state appealed it. They appealed the dismissal to the Court of Appeals, which is the next level up.
Is this in Washington State?
Yeah. But the Court of Appeals reversed based on its interpretation of the plain language of the statute. So the Court of Appeals explained that the statute does not include a course of employment limitation because there are express limitations in the subsections. So in the subsections of the statute, which clearly show that the legislature did not intend to include such a limitation for subsection 1A. This is what they're saying. And the court held that the, quote, mandatory reporting duty for the professionals identified applies in all circumstances. So, meaning that the teacher can be subject to the prosecution for failing to report. That's what they then said.
Right. And that's consistent with my memory of when I was reviewing this with ethics experts and CPS as well. And again, I'd have to look at my notes, but I remember writing down furiously that it doesn't say that you're not required, but we don't think you're required. I remember that kind of language and thinking, it's not very helpful. You know, maybe we can get some legislatures on this who can clarify this, because I imagine that the people, and therefore the government, are not interested in forcing people when they're at home talking to their kids to make a report. You know, the reason why this is all set up is because there was a case, I can't remember the exact details, but there was a child being abused, and they had told, I think, a teacher, I'm not sure, or a medical professional, and that professional did not contact the authorities, and then I think that kid went on to be killed, murdered by the abuser or something like that.
Was that here in Washington?
I can't remember, but it was, this is what's coming up in my memory banks. Who knows? But usually that's when laws get passed, is when something like that happens, like with Terrasoft or something. And that wasn't a law, that was a court precedent. But anyway, so the spirit of the mandated reporting law is that we want professionals to be forced to really go beyond, because it's not natural for us as therapists in particular to make reports on people and break confidentiality. So it's just like, look, we're going to take it out of your hands. And we also, you know, we're not going to stand for this anymore. You can't be told things and just get away with not doing anything about it. And we want to protect children. We want to protect people. So it was that. But from my memory, they weren't thinking we want to force parents when they're at home being told by their own kids to make a report or else, you know? Well,
and also because there's a constitutional right, parents have a constitutional right to the care, custody, and control of their children.
Right.
So they
their
have
autonomy
the right,
as parents.
Right, exactly. To raise their children in the way that they see fit.
Yeah. And we can criticize and say that maybe the mother didn't do enough and should have done more. And of course, the perpetrator should not have harmed the children. That's the main thing. Okay, but do we want the law to extend into the home in that way? And I think most people would say no. I certainly would say no.
Well, there is a section further in that same statute that actually does say that any person living, and it starts out with any practitioner, and then gives a whole sense of who the practitioners might be who are supposed to report. Then later it says any person living with a child who has severe abuse, where there's severe abuse, then that parent does have to report.
Really? Mm-hmm. So parents are mandated reporters?
Well, if it's severe. And so then it goes...
What is severe mean?
So it goes on to define severe as basically if there's a wound or swelling or broken bone or harm or death, you know, great harm or death. And it actually, if I can get it in front of me, then I can...
So you just have... So typically that would be a parent.
Or anybody who lives with the child.
Any adult who lives with the child.
Any person who lives with the child.
Any person.
They use the word person.
So a fellow minor?
Possibly. I mean, a fellow minor wouldn't be under...
they're a person.
Yeah, but I mean, they might, if they're not old enough, they might not be considered culpable for that.
Yeah. Well, either way, I did not know that. Huh.
You might say adult person.
I mean, you know, if the law overall and the reduction of freedom of citizens results in less harm of children, then I'm all for that, because you should make a report. But I don't know. I don't know how I feel about prosecuting, because you know there are circumstances. If you're the spouse of a perpetrator, you might be terrified yourself. You might be gaslit yourself. You know, the consequences to making a report aren't just that the perpetrator would be upset with you. You could be stigmatized. You know, it's all sorts of horrible things. The perpetrator could be so monstrous that if you are forced to make a report, the perpetrator might have already laid the groundwork to take the kids away from you, and because that happens, you know.
Yeah.
So to force people, I don't know. I'm not a fan of these blanket requirements without consideration. But I don't know. Sometimes 99 times out of 100, it's worth the reduction of freedoms of people. Do you have any opinion on this, or can you state an opinion on this?
Well, I mean, this is why it's so complicated, and this is why it's highly nuanced and very complicated, and you have, like, for therapists, you have this duty to maintain confidentiality, which is a very, very serious thing. Because if you were to violate somebody's confidentiality, there can be hell to pay. There can be a real, in terms of the Department of Health, there can be sometimes dire circumstances, dire consequences. And that's what makes this so complicated and so difficult, is that these are the kinds of situations that you're faced with. And when it comes to abuse of a child or of a vulnerable person, when you consider that you could end up in jail for not reporting, it's very serious. And so these are why, to the extent that we can, it can be good to have these laws. But on the other hand, sometimes these laws are left really kind of open-ended. I've kind of come to the conclusion that sometimes they're left open-ended because not everything is very straightforward.
Yeah, I think a lot of times it plays out, if it's done right, that the prosecutors will only prosecute the rare situation where this law actually morally applies.
So let me just correct myself. So it does say it could apply to any adult who has reasonable cause to believe that a child who resides with them has suffered severe abuse. And then severe abuse means any of the following: any single act of abuse that causes physical trauma of swelling, or more than one act of physical abuse, trauma of sufficient severity that, if left untreated, could cause death; any single act of sexual abuse that causes significant bleeding, deep bruising, or significant external or internal swelling; or more than one act of physical violence, each of which causes bleeding, deep bruising, significant external or internal swelling, bone fracture, or unconsciousness.
Okay, well, the physical abuse side makes sense to me, as the language is, I think, sufficient to catch what I would consider to be severe physical abuse. But the sexual abuse thing is very strange to me, because if you say to me, where's the threshold between, say, moderate and severe sexual abuse, it would not be indicators of blood or physical trauma that that wouldn't even be a part of the equation. It would be, I suppose, the extent and the number of incidents. But even that, is harder to feel confident in, because you can have, for example, a family member leer at you and have that be and not even touch you, and have that be extremely harmful to the child. So that one's harder to do. But I certainly wouldn't say, well, when there's bleeding involved in the sexual abuse, that's what determines whether or not something is severe or not. But anyway, that is a pretty high bar that I would imagine a lot of cases of abuse of children, those criteria are not met. So the other parent isn't. So is that's the Washington law, right, that you're reading?
Yeah.
And are we to assume? Well, no. So because that wasn't at play. That other law wasn't in this case with the teacher mom. Anyway, so it goes to the appellate court, and they reverse the decision and say, actually, the law says that the law doesn't stipulate that when you're at home, you're released from the mandated reporting requirement. Did they go to the? I thought you said they might go to the.
Then it went to the Supreme Court, where it was reversed again.
Supreme Court of Washington. And
not of the United States.
And they ruled what?
It only talks about the people in their professional role. So it's when they're in their professional role. It says when any practitioner, county coroner, medical examiner, law enforcement officer, it goes through all these things, but they're all professional roles. And those are the people who have to report and have no more than 48 hours.
So the Supreme Court of Washington agreed with the trial court that the mother was not required to make a report because she was not in her professional capacity when
Correct.
she heard the report from the kids.
Right. And basically the professional capacity, nor were she their students. It doesn't say that they weren't in the same school, so that might have been a factor, but they cleaned it out by way of saying.
So is the Supreme Court saying that if a student had, say her daughter goes to her school, the daughter goes to her school, the mother is not the teacher of her own daughter, but the daughter invites a couple friends over from the school, and one of those students that are at a birthday party at the teacher mother's home discloses that she was being sexually abused at home. Is the Supreme Court basically saying that she would be required?
Well, see, that's a very interesting question, and that's an interesting thing about courts is that they only answer the question being asked.
Yeah.
Because they don't want to open it up to all those other things. So, because it gets so complicated. So that question wasn't asked and it wasn't answered.
Okay.
So that would still be, a person could say, well, they might base a whole argument on that, imposing that piece.
Yeah.
But that's not what it.
I guess the argument that I would make based on how the Supreme Court interpreted the law, which I tend to agree with, and I would recommend the legislature actually clarify this because that would help. That's always my thing. It's like, why are we spending all this time and money on trying to interpret the language, and the legislature could just pass a law that would clarify this? But anyway, I would hope that they would say that the teacher mother in that situation is not operating as a teacher at home. She's talking to her daughter's friend and therefore is still not mandated to make a report. Whereas if she was at school and her daughter came into her classroom with her friend and the friend disclosed having been sexually abused at home, then although it's her daughter's friend that's coming into her class, even if the student wasn't a student at the school, she's sitting at her desk at work and just happens to be talking to a minor who just happens to be her daughter. And therefore she is mandated to make that report. That would be my hope as to how that would be adjudicated in the future. But anyway, okay. So that's interesting. It answers, I guess, one particular question, but doesn't answer a lot of other questions as to what we're supposed to do.
Right. For instance, it asks, does it apply to teachers when their own children who are not their students? So what about another child who is not their student? Would that apply? We don't know.
Yeah.
Or another child who is their student. Does that apply? We don't know.
Right.
If it's their student in their home. So, yeah, cases, they give you insight, and if there were a similar thing, it's, as I say, there still might be one fact that would turn the whole thing on its head. Right. But it only asks about this.
Yeah, another scenario I can imagine that would add nuance is that if the teacher mother were to have, say the teacher mother's daughter invites a friend over, and the friend comes over to the teacher mother's house as a friend, and they're hanging out, and then the neighbor kid asks the teacher mother about some homework, just casually. Like, oh, I had this homework thing and I don't know how to do this math problem. And the teacher mother, thinking that she's operating as a mother, says, oh, well, you do it like this. And then that kid 10 minutes later discloses that she was being sexually abused at home. Is she operating as a professional in that moment, or is she operating as a mother giving advice about math? Yeah, I don't know. Because it's not a formal tutoring, which would be a professional role, right? Again, I just wish when legislatures write these laws, because, from my understanding, they spend a lot of time making sure that when they do pass a law, the original law or the revised law regarding mandated reporting, they really pour over the language, and they must understand, or there must be someone that raises their hand and says, by the way, this is a potential problem because we're not stipulating whether or not they're mandated to make a report when they're like at home, for example. We're not saying either way, and it's unclear, and it's going to potentially cause a lot of red tape at the very least and confusion and potential harm to people. So might we actually clarify that? I don't know.
It's very complicated. And another example for me is that I've seen a lot of cases where a judge will prescribe, in essence, therapy for a certain, high conflict family. And that's also, it's kind of surprising because often the therapy actually isn't what many therapists would say would be advised because it could lead to abuse or neglect or just incredibly high conflict circumstances. And yet, so to have you're asking for the legislature to be writing these rules better, which I understand, but how would they write them? I mean, they don't have the insights of some of these professions. So.
Right. I mean, hopefully they would ask us and we would actually provide context, and since they're the legal people who write laws, they would be able to put our intentions and wisdom into the language, Yeah, I've had judges, like what you're saying, it's one thing to require someone in court to have an assessment and follow the assessment, right? Like in the case of domestic violence treatment or chemical dependency treatment, the court hopefully doesn't say you must be in chemical dependency treatment. What they usually will say is you need to be assessed and you need to follow the recommendations. Us clinicians would appreciate that more than the prior. But yeah, some judges will just say you're mandated to therapy. And it's like, well, what if that's not the recommendation? Yeah, I don't know if I ever told you this story, but this was, 20, 25 years ago. I, at the time, was a therapist, a family therapist, and I was also a professor of family therapy. That's relevant to this story. And I was in court not as an expert witness, but as a support person to both sides, the plaintiff and the defendant. The plaintiff was the parents, the defendant was the child, and it was a chins hearing, probably in all likelihood, and I won't go to the detail on family law and family court, but it has to do with situations in which there's conflict in families and DSHS is involved anyway. And sometimes I am asked questions by the court or by the lawyers or by the family, but I'm not there as an expert witness, and I'm not there on either side. I'm really there for everybody. And I think the defendant, the kid, was trying to defend themselves with a number of bullet points. And one of the bullet points that they brought up through the lawyer was that I, as the family therapist, was meeting individually at times with the parents and with the kid. I would have full family meetings, and then I would meet alone with the kids sometimes. I'd meet alone with the parents and blah, blah, blah. And the lawyer, I think on behalf of the teen, was telling the judge that I was not operating ethically or within the standard of care as a family therapist because I was occasionally meeting individually with some of the members. And to be clear, again, as a professor of family therapy, I know the standard of care when it comes to family therapy, and I know the options, and I know the reasons why you would do that and why it would actually be recommended that you actually meet individually with people at times for various different reasons that were not discussed, by the way. Just the fact that I had met individually occasionally with some of the members, and the kid says this and the lawyer says it, and the judge took that and just started to berate me.
Yeah, that's
Have I told you this story before?
No.
She just started to berate me. And I'm, if I were an expert witness or if I was there for one side or something, then it would compel me to try to please the judge on some level. But I was just there as a courtesy to everybody, including the judge. And she's humiliating me in front of everyone. What are you doing? I mean, and it was completely unprofessional. It'd be one thing if she just says, oh, sounds like you're not following the standard of care or whatever. But she was like raising her voice and she was being insulting. And some things that happened around then that I was like, oh, judges, there's a bell curve of competence and emotional fitness. These are human beings. I don't care if we all have to stand when they walk into the court. Some of these people are complete idiots and should not be in their position. And because, again, tip of the iceberg, if you're that stupid to extend yourself into a field that I'm a professor in, and you don't even ask me. She didn't say, is that the standard of care? She didn't ask for any input from the one person in the room that knew the answer to the question. Going off of what a teen was saying, and obviously I still have feelings about this, but this was not the only time this happened. This stuff like this started happening, and I was like, wow, I hope I never have to go to court, because what if you get one of these judges that just has no idea what, they don't even know how to think straight, let alone how to adjudicate law, particularly in family court. It's so emotional and gray area.
So do you go to court? Do you have a thing that you don't go to court?
No, I will, but it depends on the situation. If I'm an expert witness, it's kind of a different situation. I make sure that all my T's are crossed and all my I's are dotted if I'm in a forensic situation. No, I continue to go even in that capacity, but I no longer trusted the judge automatically. I needed to learn through experience if the judge could be trusted by me as an intelligent, careful professional in the room. I really, I think what a lot of people have is this idea that judges are vetted and smart and careful and wise, and they have a robe and they're up on high like a priest or a god or something, and we all have to stand up when they walk in the room, and everyone talks very carefully to them, right? Even the clerk talks very carefully to them. But as someone that didn't have any vested interest in anything, when I would walk into those courts, like, I had the freedom to just not kiss up to them and just kind of see it for what it was at times, which is just like, this is all just a big farce, and we're all handing our lives over, or at least the plaintiff and the defendant are handing their lives over to this judge, and I don't know if this is the way things should be at times. Having said that, there were plenty of judges that were, had my full respect because they earned it, but I don't know. I guess I just still have anger about this.
I have questions about whether anything should be, and they are questions. I'm not implying a response, but that bringing any kind of a therapy situation into the court is, first of all, likely to harm the therapy, really very likely to harm the therapy, if not destroy it completely, except that there might be some moment or incident where it could have a positive effect and a reasonable application. But it's when you think about the language of therapy versus the language of court, it's like, it's actually the worst of combinations, because it's where people think they speak the same language, but they don't. So if you were to listen to a therapy session where a therapist might say, it's almost as if blah, 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 or maybe you feel that I'm your mother and blah, blah, blah. That would be a perfectly reasonable premise to make in a therapy session in order to get a point across, or in order to better understand a person's fears or responses. But in court, like, it's almost as if, what does that mean? Nothing. It means nothing.
I never thought about that. Yeah.
And so the whole, or, just tell me how you feel. And a person might say, I hate them. That's not saying that they hate them. They just answered the question, how do you feel? Like, what's in the pit of your stomach at this moment? Right. And if you were to take a transcript of it from a legal point of view, it would go off into a whole wrong direction.
Right.
That lawyers, they just don't understand the way that the language is being used. And likewise, if a therapist goes and testifies in court, they don't necessarily understand the way the language is being, like, I've seen where a therapist might say, well, I would recommend blah, I recommend you get a GAL. Well, that recommendation, the use of that word from a clinical context is not the same use of the word from an expert witness context.
Right.
And that therapist was held to task for having used the word recommendation. So, really to have the two types of practitioners, or the two types of processes under the same roof is terrifying, actually. Because or if a therapist, like, this is another thing, is that therapists are taught to write notes for clinical reasons. There's a clinical reason to have a note, which is basically to remember what went on, or to understand whether the goals are being met, or to have continuity of care. so that either I can look at, or the person can look at the note a year later and see what progress they made. Or if the client goes to another therapist, you can get the note and they'll see what was done. There's an important clinical reason. And so for the most part, people write clinical notes. And then something happens, like outside of your purview. Your client has a child, or they get married, or they live together or something. A client makes a life choice. Now, all of a sudden, those notes that the clinician wrote for clinical purposes, those notes are now legal documents. They're now notes that are going to be scrutinized under a legal lens because they were not written with that in mind. They were not written from that point of view. They were written for clinical purposes. Yeah. So it's just a whole, and as I said, everybody thinks that they understand the same language when they don't. Even just when someone says, let's continue this. If your therapist saying, let's continue this, that means let's keep talking about it. If you're a lawyer who says, let's continue this, that means we're going to postpone.
Yeah.
That means we're not going to talk about it.
Yeah. I learned early in my career when I was asked to testify, and I was not provided any legal advice. My supervisor, I don't think, gave me any kind of advice. I'm like 27, and I'm just like, doopy-doo, okay, I'll testify.
I'm a smart person. I know what to do.
I was there thinking, well, we're all adults, and there's the truth, and they'll ask me, and I'll answer the questions, and whatever the very wise trier of fact will determine will, of course, be the right thing if we all just tell the truth. Well, I sit down, and what I would learn is the opposing attorney, which I didn't consider that attorney to be opposing because I'm just here to tell the truth.
Right. Mm-hmm.
That attorney just started coming after me and probably in a very effective way discredited me and attacked me. Mm-hmm. Attacked me, I think, to discredit me even before that attorney knew what I was even going to say. I think the attorney just figured I was for the opposition or something, and I wasn't. I'm there to tell the truth. I'm not on anyone's side. I'm on the side of truth, and I was literally shaking, feeling this threat of this lawyer at just his attitude toward me. And I remember even at some point saying, like, Mr. Attorney, do you think I'm lying to you? Or I don't know, what's this attitude I'm getting? And the judge actually said, you just have to answer the questions. And I'm like, oh, well, what's happening right now?
Yeah, and I bet that if lawyers were there, they probably would have said that he wasn't even that bad.
Right.
What was going on. That's just typical. Being in the court, like I help prep clients for testimony, not coaching them, but prepping them, like just what you didn't get, like just understanding that this is going to be adversarial, or understanding when you might not have to answer a question, or even having a lawyer there with them. And one of the things that clients will always say is, I'm just afraid that they're going to make me look like an idiot. And I say to them, don't be afraid. They will absolutely try to make you look like an idiot. That's how they see their job, is they need to impeach. It's called impeaching. They need to impeach you so that they kind of knock your point of view out of the park. I mean, knock it out of the court system so that it's not counted. It's discounted. And it seems completely unreasonable. Like, why do you have to do that? Why can't you just figure out what the problem is and work with that? But it's an adversarial system, and that's why they do it. And it's unfortunate, because I think it's going to start to really have an effect, or I could understand if it had an effect on who wants to work with people, whether therapists will want to work with people in these high conflict cases that go to court. Yeah. Because therapists are usually not high conflict people. Right. They're looking for people to come together. Yeah. Not to be,
Yeah, and I advise my supervisors to do this, and I've done it myself, that if I have a prospective client reach out to me that it seems extremely likely that they're about to head to a custody battle, then I will sometimes not work with people like that just because of that risk, because I don't want to have to deal with it personally. That's not what I'm here to do. And I also predict in situations like that, depending on what I'm hearing in the screening process, that no one really is there for therapy. They're there to try to win me over so that I will testify one way or the other, and that's not why I got into this business. But yeah, I mean, I would eventually learn all this when I was being trained as a forensic psychologist, because arguably half of what you need to know and be trained on is how to respond to cross in court, how to justify your testing procedure, how to be very buttoned up about your testing procedure, how to follow the standard of care, how to report on what's in the report and nothing else, how to write the report, how to justify your expert status, all that stuff. It's all just by the book, and you know for sure in a forensic situation you're going to get attacked, is my word, by the opposing attorney, and it's all just baked into the whole system. You go in absolutely knowing that, and from the very first moment of your assessment process, you're planning for that cross-examination,
right,
and preparing for that. So it was, it was very different by the time.
But being a forensic, so then you're not giving therapy. You're not doing therapy with them. So, but that makes all the difference because as a therapist, to then have to go back to performing therapy where you have a duty now of care, where you're basically supposed to put that person's needs first.
I mean, if we're talking about like the cases in the past, like the one I was talking about where the judge was berating me, those were situations where I was hired by the state, by the government, to help families that were in crisis, and I was contracted for a certain amount of time. And many of these families were already or were soon to be in court, and it was recommended or an expectation, or it wasn't really required of me, but it helped if I was in court to see what was happening and honestly could influence things one way or the other. And with some of the judges, the better ones, they would turn to me because they figured I knew a lot more about the situation, and then I was on everyone's side. I was the one person in the room. They couldn't really go to the lawyers for that kind of unbiased opinion. They certainly couldn't go to the different parties, but they could ask me, and I could answer the question. I'd be like, well, here's my hope, and and I would talk strength based. I would say the parents have a lot of strength, and the kid have a lot of strength, and here's what and all that kind of stuff. And also the wise judges knew that once the hearing was over, I was in a prime position to actually do what was on everyone's mind in terms of hopes, which is actually to protect the kid and make the family functional. So the bigger picture, it was like I was a very important person in that room. The lawyers weren't going to extend into the future. The judge wouldn't. And even the DSHS workers that might be also in the room, they don't have that power to actually change the families the way I did. So, it sometimes was extremely important that I was there. But yeah, I mean, the question is it wise that I'm there given the potential negative impacts on treatment? Yeah, I mean, it was a thing. It was a consideration. But it could even be asked in the opposite of like, is it wise for me not to be there given the consequences that could happen? At the very least, just not being informed, because a lot of the times the things that would happen in court really impacted the therapy and stuff. But another function that I was there for was like, because when you go to family court, a lot of times you're just sitting in the waiting room for like 5 hours or even a couple days sometimes. And the family gets stressed out, and and I can be there to help them get through those times, or they're really worried about what's going to happen, and I could say, well, let's try to work this out anyway. So I guess all that had to be balanced out, but yeah, I clearly still have some pain about being berated in court by a judge. It didn't feel good. It also, I guess, was a wake-up call to the reality, again, that some judges aren't competent, in my view. And I am still, I guess, grieving that reality, because I grew up thinking that they were, like, really smart and really wise and really level-headed. And to lose that assumption is to not feel so safe in the world anymore. You know, I guess it's similar to like the first time you realize that not all police officers are good people. You know, it's like, oh my God, what does that mean? You know, you just want to believe anyway. Well, thanks for coming on the podcast, Fran. If you're up for it, I want to have you back on when I do get one of these briefs from my malpractice insurance, and we can review the case as it's written up by my malpractice.
So I don't understand, a brief from your malpractice?
Yeah, they will send out these anonymous case briefs of cases that they're involved in, and as a way for mental health professionals to understand the risks and the practices. There's always recommendations at the end. It's an educational tool.
Oh, yeah, that'd be interesting.
And it's really interesting because, as you've been saying, every case is different, and there's all these nuances, and there's all these details that you have to get into. And I usually will review these briefs with my friend and colleague, Bob, but he recently told me, after doing this on the podcast for, 7-8 years, that he hates doing that kind of thing because it stresses him out. So I don't have anyone to do it with anymore, so maybe you could do it.
Oh, great. That'd be fun. Let me know next time you get one.
Okay. Well, any parting words, any summary, any final word from Fran, attorney therapist?
Well, I'm always wanting to think that people should have good disclosure forms. They can go to they can go to the workingalliance.com. I'm
surprised you even got that URL because it's an important concept in our field.
The Working Alliance,
that no one else grabbed.
I know.
Yeah.
It's surprising. So, so go there, take a look at some of what we have to offer, and because it's so important that you have a good disclosure form. So check it out, and it's been great talking to you. Always interesting, and I'll look forward to more.
And everyone out there, please take care of yourself, please. Why should people take care of themselves, Fran?
Well, because it gives them the strength to go forward.